So, for those of you who haven't met me before, my name's Kim Baker. I'm a HR consultant at RBHR Consultancy. I'm presenting today's webinar on employment law. I'm also joined behind the scenes by my colleague Beck Hewitt-Stephan, and she's going to be operating the presentation slides for me today. So let's take a look at today's webinar agenda, which is going to give you a heads up on some of the things we've got coming up at RBHR Consultancy. So we've got employment law changes. We're going to be covering what's happened so far, employment law changes which are coming up, other proposed changes. We'll do a summary of what we've discussed this morning as well. We'll be time for questions, and then we'll do a brief run through of RBHR Consultancy and the services we offer, along with some talk about some of the training we can provide as well. Okay. So let's look at what employment law changes have already taken effect in 2024 and what this means for employers and more specifically HR teams. So we're looking at the right to request flexible working. As of April this year, all employees now have the right to request flexible working from day one of employment and can make 2 requests in any 12-month period. So employers are required to consult with the employee before rejecting a request and will need to deal with the request within 2 months. There's also been changes to carers leave, so a new statutory entitlement to unpaid leave for employees who care for a dependent with a long-term care need now applies from the first day of work. So what does this mean? Managers should be supported and trained in handling such conversations appropriately. Ensure these legislation changes are communicated to your wider workforce. Regarding carers leave, it's also a good idea to consider which of your employees might request carers leave so you've prepared for any future requests and have adequate staffing levels in place. And also, despite the potential for the business to refuse flexible working or carers requests based on business need, employers must consider the discrimination risks, and this is becoming more and more prevalent as we're seeing at the moment. So next slide, please, Beck. Let's take a look at what other employment law changes have already taken effect in 2024. So we're looking at the Protection from Redundancy, Pregnancy and Family Leave Act 2023. Under the new legislation, pregnant employees and some new parents have special protection in a redundancy situation, which applies for up to 18 months after the birth or placement of a child for those taking maternity, adoption or shared parental leave. So by law, the employer must offer them a suitable alternative vacancy if there is one. We also got changes to the Paternity Leave Amendment Regulations 2024. So an employee can split their paternity leave into 2 one-week sessions to be taken at different occasions and can take paternity leave at any time up to 52 weeks from the date of birth or placement, providing they give their employer 28 days notice. So we're saying managers should be supported and trained in handling such conversations appropriately. Ensure these legislation changes are communicated to the wider workforce. The changes to the protection from redundancy do not stop employers from selecting employees with priority status for redundancy. However, the protection applies when it comes to the allocation of alternative roles. Employers should also consider what level of payment they want to make for statutory paternity leave as a matter of policy, because offering full pay is becoming increasingly the norm. Next slide, please, Beck. So I'm sure this will be a relief to some of you. The UK government has announced that the Workers' Predictable Terms and Conditions Act 2023, originally set to come into force this autumn, will not proceed as planned. This act aimed to provide workers with uncertain hours the right to request predictability in their working pattern, including number of hours and contract length. However, while this specific legislation has been scrapped, the government is expected to introduce similar provisions in its forthcoming Employment Rights and Make Work Pay programme. So the scrapped act was intended to address the challenges of zero-hour contracts, and other atypical working arrangements where workers are often left without guaranteed hours but are expected to be available on short notice. So watch this space on that one. Next slide, please, Beck. So here's an overview of upcoming employment law changes, which will now go into more depth on the following slides. So coming into effect today is the statutory code for the fair allocation of tips. And at the end of the month, we're seeing the Worker Protection Amendment of Equality Act 2010 and relevant secondary legislation coming into force. Just have a drink before I proceed with the next slide. Next slide, please, Beck. So from today, the statutory code for the fair allocation of tips comes into force. The code forms part of the Employment Allocation of Tips Act 2023 and gives guidance for compliance with the Act. And it means employers must fairly allocate tips over which they exercise control or significantly influence. Tips should be paid to all workers in full before the end of the month following the payment being made. Self-employed or exempt, employers must produce a written policy on tip allocation or produce an exemption certificate. And employers must maintain records of tip allocations for 3 years. So that comes into force today. Next slide, please, Beck. So from the 26th of October, the Worker Protection Amendment of Equality Act 2010, Act 2023. From October, the Worker Protection Amendment of Equality Act 2010 will strengthen existing protection for workers against sexual harassment. The new law will place a new duty on employers to take reasonable steps to prevent sexual harassment, and tribunals will have the power to increase compensation by up to 25% if they find an employer has breached this duty. Next slide, please, Beck. So it's important to note that this is not a tick box exercise, and employers will need to show evidence of the reasonable steps taken. Organisational and cultural change requires senior leaders to set the tone for workplace behaviour, promoting values like dignity, respect and inclusion. Written policies, while not sufficient alone, are important in defining sexual harassment, outlining responsibilities and reinforcing the organisation's commitment to preventing it. Regular training ensures all staff understand their role in preventing harassment, and effective reporting channels and swift investigations are essential for addressing complaints. Line managers will need proper training to handle harassment confidently. And finally, monitoring gender diversity and conducting staff surveys can help potential issues related to discrimination or harassment. Next slide, please, Beck. So we thought we'd give you all a little bit of a test this morning to make it a bit more interesting, because I'm aware employment law can be a bit of a boring, dull subject. And there are numerous misconceptions circulating at the moment regarding current UK employment rights. So I thought we'd do a quick true-false session to dispel some of the rumours. So hopefully the chat's enabled and you're able to put notes and comments in there. So feel free to put true or false based on the questions. So the first one, employees can make a request for flexible working from day one of employment. So we're asking you whether that is true or false. So I'll give it a few moments for people to put their answers in the chat. You saying it's true? Anyone else want to put their answer in the chat? Okay, that one is actually true. However, employers do not have to grant the request. Ooh, we've gone a bit too far, but sorry about that. Don't worry if you're having problems, but we'll do the run through at the end. I'll just ask the questions now. So 0-hour contracts are banned. Does anyone want to have a stab whether that's true or false? Someone's saying it's false at the moment. Someone else saying it's false. A couple of falses coming through. So that one is actually false. So at present, 0-hour contracts can still be used by employers. So the next one, statutory sick pay is paid from day one of sickness. Waiting to see what people say on that one. Oh, someone said, I don't think everyone can access the chat. Okay. Okay. It says some people in this chat are outside your organisation. It's possible they're message-related policies that will apply to the chat. Wondering if that's blocking people. Okay. Bear with one moment. Sure if there's a way of fixing that or not, Beck. Okay. Apologies to those of you who can't access the chat. We'll run through it anyway, and we'll go through the answers, but you know whether you've got it right or not. So statutory sick pay is actually false. It's paid to employees who are off sick for at least 4 days in a row. Dismissal and re-engagement, also known as fire and rehire, is illegal. Again, that's actually false. Fire and rehire is not currently illegal. However, employers should follow the statutory code of practice on dismissal and re-engagement. And the final one, school-aged children are not entitled to the minimum wage. That one's actually true. Children under 16 do not pay national insurance, so employers only need to include them on their payroll if their total income is over the personal allowance, which is currently £12,570. So next slide, please, Beth. So what other proposed changes are coming in? The Employment Rights Bill. Labour pledged to introduce the bill within their first 100 days in power. The bill is described as the biggest upgrade to workers' rights in a generation, and it's expected to be presented to Parliament by mid-October. The bill must pass through both houses of Parliament before receiving royal assent and becoming law, a process which could take several months. After becoming law, new codes of practice or secondary legislation will likely be needed. So for those of you a bit worried about this, changes are unlikely to take effect before 2025. So it's a good idea to know what they are and to be prepared, but we're not expecting anything to happen this year, this side of Christmas. And the Employment Rights Bill will also establish a new state enforcement agency called the Fair Work Agency. And this new body is likely to have powers to enforce working time, holidays, pay, sick pay, agency rules, and discriminatory practices against migrant workers. And it's also been reported that its remit may also include parental rights. Next slide, please, Beck. So other proposed changes include the draft Equality, Race and Disability Bill. And this bill is described as a draft bill, which suggests that it's of lower priority than the Employment Rights Bill. This bill is likely to require a lengthy consultation, and as such, we expect that this bill will take longer to pass through Parliament. But again, we'll keep you updated as and when we know more. Next slide, please, Beck. So let's focus on the potential impact of the Employment Rights Bill, which talks about day one rights and unfair dismissal. A significant development is the proposal to grant workers new basic individual rights from their first day of employment, eliminating the current system where workers may have to wait up to 2 years to access fundamental protections such as unfair dismissal, parental leave, and sick pay. So changes to sick pay, such as removing the 3-day waiting period and removing the lower earnings limit. Other proposed changes include a ban on exploitative clauses in zero-hour contracts. So employers will have a new right to a contract that reflects hours they regularly work based on a 12-week reference period. Fire and rehire. Reform the law to further restrict fire and rehire and fire and replace practices and replace the new statutory code. Protection for new mothers. So we also talked about from the 6th of April this year, women selected for redundancy have had the right to suitable alternative employment if they're pregnant, or if their expected date of childbirth was less than 18 months ago. However, the Employment Rights Bill will go one step further and introduce protection for employees returning from maternity leave, preventing dismissal for 6 months post-return, except under specific yet to be defined circumstances. So again, once we know more, we'll keep you posted. Further proposed Labour changes include unpaid internships will be banned unless it's part of an education or training course. Trade union legislation, there'll be a new duty placed on employers to inform workers of their right to join a trade union. Introduction of a single worker status. So Labour wants eventually to abolish the UK's current 3-tier system for employment status. They want a simple framework where people are either workers or self-employed, so abolishing the current distinction between employees and workers. They're removing the wage bands, so removing the age discriminatory wage bands, so all adults are entitled to the same minimum wage. Improving redundancy rights and protections, so the collective consultation duty will be triggered more easily and more frequently. Processes will need to be put in place to track redundancies and changes. There'll be strengthening workers' rights under 2P, but unfortunately at the moment, Labour's not said how this will work in practice. Employment tribunals, increasing employment tribunal claim time limits from 3 months to 6 months. And further changes include extended protection for whistleblowing. So Labour says it will strengthen protection for whistleblowers, but again, they haven't said how, except it seems likely that employees who report sexual harassment will be automatically counted as whistleblowers. They'll be reviewing legislation for unpaid carers leave. So the right to 1 week unpaid carers leave came into force in April this year. Labour are going to look at making this a paid entitlement, but is not promising to do so. Sexual harassment legislation, again, further strengthening existing protections, potentially employer liability for third-party harassment, and strengthening duty on employers to prevent sexual harassment. Menopause action plans to be published for employers with 250 plus employees. So many employers already have policies which could be converted into action plans. So this shouldn't be too difficult a step for a lot of companies. Equal pay, an end to outsourcing to avoid the Equal Pay Act. So the upholding the public sector equality duty and both ethnicity pay gap reporting and disability pay gap reporting for employers with at least 250 employees. And finally, next slide, please, Beck. The AI surveillance technologies, which will be subject to consultation. So Labour plans to require employers to consult worker representatives before introducing surveillance technologies. Labour is rumoured to favour stronger regulation of AI, including a requirement on employers to monitor for bias or discrimination before deploying it. But again, the latest proposals are non-committal. The right to switch off, I'm sure you've all heard of this one in the press. Labour says it will bring in the right to switch off, giving workers and employers the opportunity to develop workplace policies or contractual terms. Details are currently unclear, but Labour's New Deal mentions Ireland and Belgium as possible models. Change to tips. So Labour would ensure workers receive their tips in full. There seems to be a commitment to continue with the TIPS Act, which came into force today. Non-compete clauses, so limiting these to 3 months only. And self-employment, Labour also intends to approve protections for the self-employed, including the right to a written contract. Okay, next slide, please, Beck. So we're also talking about the Draft Equality, Race and Disability Bill. Labour currently plans a draft bill to extend the right to make equal pay claims to Black, Asian, and minority, ethnic and disabled workers. Labour have previously spoken of plans to enact the right to claim dual discrimination. So this is where someone claims they've been discriminated against because of having two protected characteristics, such as because they're a Muslim woman, or but this wasn't mentioned in the King's Speech. So let's summarise everything that we've talked about so far. The upcoming legislative changes mark major shifts in employment law with broad implications for both employers and employees. Businesses must stay informed and take steps to prepare, ensuring their policies and procedures are aligned with the new regulations as they take effect. So does anybody have any questions? Try to see if I can see the chat, see if anyone puts any in there, but I know we're having problems with that as well today. Someone's asked whether we envisage a significant increase in flexible working requests as a result of the day one change. I think personally, I would say we are going to see more requests, but I think although it's a day one change at the moment, you've still got the right to request it earlier, although the employer doesn't have to grant it. And I think if it's a day one change, will we see a significant increase? Yes, we will, but I'm hoping there'll be some guidance like there was before about how we can manage the requests. So it's not a significant influx from everybody. Not everybody's going to make a flexible working request. Some people, when they join a company, are going to be happy to work full time. Some people are going to ask for what they want at interview, which is possibly what happens anyway, without making a formal request. So I think we'll just have to wait and see. But yes, I do expect there will be more. but I don't think it's going to be unmanageable personally. So I appreciate that there's a lot of information to take on board with the proposed employment law changes. Feel free, once you've had a chance to process and mull over today's webinar, please feel free to come back to me or one of my colleagues should you have any questions at all. And I'll talk you through a bit more about RBHR and the services we offer. So if you do have any more questions, feel free to put them in the chat. Next slide, please, Beck. So about RBHR consultancy, for those of you who are already clients of RBHR, you'll be aware that you can pay for a time bank if you have a specific HR query which falls out of your retainer. So the HR time bank, pay for the time you need, and we generally say it starts at 12 hours and you get a dedicated HR consultant to manage the process from start to finish. I think some people have left and are coming back, so just bear with us one moment. We also provide training, and we'll talk about the courses that we can provide on the next slide. So we've got a variety of training courses, which we can deliver both face-to-face and remotely. So in light of recent legislation changes, we've put together a training course, Respect at Work, to try to cover these areas. The training programme lasts approximately 1.5 hours. If you're interested in hearing more about the training that we provide, then please feel free to drop a message into the chat, or you can email me so that we can contact you at the end of today's webinar. We'll also be doing some future RBHR webinars on different topics. So on the 12th of November, we'll be talking about subject access requests. We're also doing a topic on probation in December, menopause on the 28th of January, and we'll be talking about recruitment in March. So again, if you do have any questions and the chat box wasn't working for you, or you think of anything after today's webinar, please feel free to email inquiries@rbhr.co.uk. And thank you ever so much for attending today's webinar. Today's session has been recorded, and as I said before, we'll be sending out the recording shortly via email. So thank you everybody for attending today.